we'll start with Ms. Duggins-Clay.
Thanks, Chair Buckley. Members, thanks so much for having me today. My name is Paige Duggins-Clay. I have the immense privilege of being the Chief Legal Analyst at IDRA, a nonprofit, nonpartisan civil rights organization dedicated to equal educational opportunity for all students through strong public schools. I'm also here today as a parent of 4 kiddos in Texas public schools, a daughter of a public school educator who was Teacher of the Year in 2021, and the just generations of public school educators in my family. IDRA opposes House Bill 3 because it does create a constitutionally inefficient and inadequate educational program that will almost certainly have a discriminatory impact on our state's most historically underserved and vulnerable student populations. I had the privilege of clerking on the Texas Supreme Court, and so I'm bringing that perspective with me today because I learned a lot while I was there about the importance and primacy of really looking at the intent and the text of a statute or the constitutional language at issue. And so I come this afternoon now with some words of wisdom, I think I'll start with, from those that preceded you, the founding fathers of Texas. Since our state's founding, access to quality public education has been of primary importance. For example, in our 1836 Declaration of Independence from Mexico, Texans boldly proclaimed that public schools are vital because, quote, unless the people are educated and enlightened, it is idle to expect the continuance of civil liberty or self-governance. Acting on this principle, in our 1875 Constitutional Convention, we established an education committee to talk about how the state was going to invest our public dollars to establish a system of education. And I think it's important for you all to know that on the table at that time was a debate about whether to invest money in a system of private schools, public funding for private schools, which sort of was the prevailing pattern of the day, or to create a more holistic, public, open system for our state. I just want to share some of the comments of the chair of that education committee from the Constitutional Convention of 1875, and he said, I boldly assert that is for the general welfare of all, rich and poor, male and female, that means of a common school education should, if possible, be placed within the reach of every child. Now, there was a lot of debate and back and forth about, again, which one of these systems the state should adopt. And one leader really emerged, Delegate Henry Klein, who was the member of the committee who actually proposed the term efficient, which really is a cornerstone of our state constitutional mandate to fund public education. And he looked around at his peers and he said, look, I see that so many of us are funding the transportation, the travel, the tuition, all of the expenses that go to private education that we can afford, looking at his peers in the legislature. And if we just took that money and invested it in our state, we could all have a great education system. So I'm paraphrasing his, but I put the quote there. I thought that was really important to acknowledge. And again, his peers on that committee expressly rejected the idea that we should be funding a private system of a publicly funded system of private education. The debate of 1875 resulted in our current constitutional clause around the public education, a general diffusion of knowledge being essential to the preservation of the liberties and rights of the people, invoking our Declaration of Independence. It shall be the duty of the legislature to establish and make suitable provision for the support and maintenance of our efficient system of public schools. Now, I want to note that Section 1 of this bill expressly invokes this constitutional duty in establishing the purpose. And so we are saying as a body that we are undertaking this new effort to fulfill that constitutional mandate, yet Texas courts have rejected this idea, and courts across the country have done so as well. And the reason for that is fairly simple. We can't create conflicting, multiple ways of addressing this constitutional mandate. There's well-settled Texas constitutional law that talks about how once the Constitution or a statute has expressly established a duty or a right or a means of doing it, we can't then do something that is the opposite. And I'm happy to talk a little bit more about that case law if that's an interest. Ultimately, Article 7, Section 1 is not just an aspirational statement. It is a carefully crafted, built on hours of debate, and it has a clear framework for providing an adequate, efficient, equitable public school funding system. I know I'm at the end of my time. There was a lot of debate earlier and questions about how this bill might create and have a discriminatory impact. I'm happy to unpack that a little bit further, but I just will point the members of this committee to the Texas Bill of Rights, which does contain a provision that clearly says that the state cannot fund discrimination on the basis of race, creed, color, or sex. And so I want to make sure that you all are aware of that mandate.
Okay.
Thank you all very much. I'm happy to answer questions.
All right, thank you for your testimony.